Everybody say, 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 how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things you've
Father, you done for me, yeah.
Words are not enough to say thank you.
So Lord, you are,
Lord, you're my everything.
Say, I call you Jireh.
Lord, my provider.
I call you Nisi. You are my battle. I call you Rapha. Hey.
You are my healer.
Say, Lord, you are.
Lord, you're my everything.
I call you
I
Jireh.
call you Jireh. Lord, my provider.
I call you Nisi. You are my battle. I call you Rapha.
You are my healer.
Say, Lord, you are. You
You're
are.
my everything.
Uya matinyana. Uya matinyana. Uya matinyana. Oh, uya matinyana. Yeah, so uya.
Moya matinina. Moya matinina.
Yeah.
Moya matinina.
Oh, uya matinyana. Say, I call you Jireh, say.
I call you Jireh.
Yeah.
Lord, my provider.
I call you Nisi.
Eunice.
You are my battle.
My back.
I call you
I
Rapha.
call you Rapha.
Hey.
You are my healer.
Say, Lord, you are my everything. Yeah. Are you ready, everybody? All right, listen. William me ground, come here. 1, 2, set.
Voy a mi cuarto, te la mamá. Me vine sola.
Yeah. I can breathe without you, say. I can move without you, Lord. Hey. Who am I without you? Say, I can live without you, yeah. I can breathe without you, Lord. I can move without you, yeah. Who am I? Who am I? Who am I? Who am I? Hey. Who am I thinking now? Oh. So, oh, yeah. Oh, yeah. So, oh, yeah.
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214-218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208-493-7340 or our emergency line 07712-761-884. Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.
Hello, wonderful viewers and listeners. Once again, you are through to the channels of BWF Solicitors. Yes, this is Community and the Law program. Very soon the program will be starting, so stay glued, tune in, join in, and let's work and learn together. So we are going to celebrate. After celebration, we'll go through our nugget. And of course, we will start with what we have for today. Very soon, we will be bringing you wonderful things. Very important topic for today. Many people have been calling, I've been banned for 10 years, what do I do? And this cuts across. So today we are going to delve into that. Whilst asking you to stay glued, we are turning around for a quick commercial break, and once we return, get ready. We are going to celebrate and go through the nugget.
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
Good afternoon. Once again, welcome back. This is the community and the law. Lawyer Asma has already introduced the program, so there's no need for me to go over again. What we have next is we have to celebrate our dear sister who celebrated her birthday this week, lawyer training solicitor lawyer Annie Soa. So, wherever you are, we all wish you a very special happy birthday to you. We pray for more grace on your life. We believe as you are celebrating this day, God will actually honor you and then take you from grace to grace, and all your what do you call it, your desires to become a very fully qualified lawyer will come to pass. So, Lawyer Anne, happy birthday to you wherever you are. So that's it. And then we have our nuggets that will be coming on soon. If my producer is there, if he can show us the nuggets that we have this week. You know, when it comes to BWF solicitors, every week we try to educate the public about few things that we need to know when it comes to the law. And we put these few bits of knowledge into a nugget form, and then we post them online, Facebook, and then what we call YouTube and other places or other platforms on the social media. And when you go through, when it comes to Saturday, for instance, these nuggets that was posted throughout from Monday to today, we try to unravel it as how the real meaning of it, and then for us to get the better understanding of what it is all about. So I have my lawyer Asma here with me. Lawyer Asma, welcome to the program once again. Thank you for the introduction as well. So this week we have something that we call it unfair dismissal and what? Reasonableness, which we need to digest it into our basic understanding, because when it comes like this, most of this terminology, when it comes to the law, we not all of us can really understand, so unless the experts are here. But let me quickly read that before Lawyer Asma break it down for us. So under the section 98 of the Employment Rights Act 1996, if an employee is dismissed, the employer must put forward a potentially fair reason for the dismissal. Otherwise, the dismissal will be unfair. And in order for a dismissal to be substantively fair, it must fall within the range of reasonable responses in the circumstances. Okay, so this means that the dismissal of the employee must be reasonable, and the evaluation of its responsibleness depends on three factors. And these factors are what we have on board: one, whether a fair investigation had been carried out; secondly, whether the respondent had an honest belief that the allegations made were true; and then lastly, whether the respondent had a genuine belief that the allegations made were true. So this act, actually 1996 Acts Employment Right, Lawyer Asma is here to actually break it down for us to get the real understanding of what is unfair dismissal is all about. So Lawyer Asma, thank you once again, and then welcome back to the program. So when it comes to unfair dismissal, what actually, with the three factors that have been given to us, what does it mean, if you can educate us on that?
Thank you very much, Na. Hello, viewers and listeners. Today's nugget is about employment law, and we are looking at dismissal. There are actually three forms of dismissal, and each dismissal has to be fair to an extent. Otherwise, the employee will have right in law. So we have constructive dismissal, we have summary dismissal, and we have what we call unfair dismissal. Now, we also have wrongful dismissal. The key point for us this afternoon is to look at whether the dismissal was fair or not. If the dismissal isn't fair, then there is a breach of statute. And the statute provision is Section 98 of Employment Rights Act 1996, which states that an employee has the right not to be unfairly dismissed. That's the provision. You have a right as an employee not to be unfairly dismissed. So how do you prove that your dismissal was unfair? And how does the employer prove that the dismissal was fair? So we know that you can be dismissed on the basis of misconduct or gross misconduct. You can also be dismissed on the basis of redundancy or terminated. Can be terminated on the basis of incapacity, that is, if you are not capable, what we call capability. And therefore, if the behavior is conduct or redundancy, conduct, then of course the employer will have a recourse to dismiss. If it is about redundancy, yes, the termination can take place. If it is about the fact that you can't perform the job, capability, the employer can't terminate you. The question remains, was the process fair? And therefore, was the dismissal fair? So we look at case law. And the case in point is the 1997 case, British Home Stores versus Birchall. British Home Stores versus Birchall is the case in point. And it's a 1978 case where the court concluded that for the dismissal to be fair, it has to be fair in all circumstances, and therefore the reason for dismissal should be fair. So fair reason. But the question here is, how do you conclude that the reason is fair? It could be that it's a matter of misconduct. Therefore, the behavior of the employee is untenable, or capability, what have you. But whether it's conduct or capability, or even if it's redundancy, did they go through the process to end the contract for the employee? So the first one is, if it's a case of conduct, the first thing that we want to establish is whether the employer had a genuine belief. In other words, whether the employer believed that the allegation based on which the employee contract is being terminated or has been terminated was true. So what we call genuine belief. In other words, do you genuinely believe that what happened was the case or was true? And if you did believe, was that belief honest? in all the circumstances. In other words, did you carry out assessment to confirm that, yeah, that was an honest belief? Therefore, it's not a matter of hearsay or it's not a matter of personal opinion, but objective assessment. And if that was the case, did you confirm that genuine, honest belief with a conclusive investigation to ascertain that belief? So, genuine belief, honest belief, and investigation to confirm that belief. If the employer did not do all this, then it will appear that the dismissal did not follow due process. There's
Okay.
also ACA's expectation that the employer has to go through ACA's 6-point process, carry out investigation, inform the employee what is happening. Suspension must take place. Of course, once you are suspended, you have to be paid because the matter has not ended. You have
Asma,
to go through all that.
Asma, sorry, let me ask a quick question before we come to the ACAS one. You see, you made mention of beliefs that from the employer having that belief that the dismissal that he's proposing is fair. And you, the employee, you have the belief that the dismissal that the employer has sustained on you is unfair. So we both have beliefs here. And when we talk of belief on the side of the employer, if the employer believes that whatever situation or circumstances is standing upon to have that fair dismissal on the employee, and you as the employee, you deem it not right, as whatever the employer is believing is not right, so you have to challenge that dismissal. And that is where you term it as unfair to you, because you are the recipient, you are the one being sacked or dismissed from the company, so you term it this as unfair. So in this case, where do we have that balance before the ACAS thing comes in? I mean, the policies of ACAS comes in. Before this dismissal will take place, obviously, the company might have gone through their own investigation. And then before they come to that conclusion that whatever we've decided is final, so we are dismissing you or we are either taking you out of the company. And then you found that unfair. So before ACAS even comes in, how do you tell or how do you go about it, telling that company or telling your employer that no, the dismissal you've given or rendered unto me is rather unfair, before we come into that of the intervention of the ACAS, if you really understand my question there?
Yes. All right. So it is not a matter of I think it's not fair. It's not you saying it's unfair or the employer saying it's fair. What is fair means that they went through the due process to
Okay.
terminate you. If they went through the steps, the processes, because there are policies and procedures in place for terminating the contract. And there are statutory provisions for terminating contract, and there's also employment contract provisions within the employment agreement between both parties for ending the contract. And therefore, if the employer did not follow their own policy to end the contract, they will say the process of ending the contract was not fair.
Fair. Okay.
So it's not a feeling, it's a procedure. So if there's a procedural impropriety, then it makes the termination unfair.
Right. I get it now. So now we can move on to the ACAS intervention, or the policies based on ACAS principle, before the company can finally, accept that unfair dismissal. Yes.
Yes, so we established that a person is an employee under Section 230, subsection 1 of the Employment Rights Act 1906. We also have to look at other provisions of the law, for example, Section 104, Section 105, Section 108 of the Employment Rights Act, to ensure that the person qualifies to bring a claim in law. And the qualification is 2 years as an employee. So we have to note that 2 years. If you have not worked for the employer for 2 years, then you don't qualify to bring a claim for unfair dismissal. So let's note that. So our presumption is that you are an employee and you have met the qualification period of 2 years working for the employer. The employer has policies and procedures. For example, disciplinary procedure, there is grievance procedure, and all that. So if it's a case of disciplinary against the employee, was the disciplinary procedure invoked and followed through? As part of carrying out the investigation, because the fact that somebody has committed an offense may not always be the case that the person has committed an offense. It might be hearsay. It might be that somebody has made a report. There could be mistaken identity. And therefore, as an employer, you have to go through the process to ensure that indeed it happened. That's what we mean by genuine and honest belief. And once you've carried out the genuineness and honesty test, you move on to conduct investigation per your own investigation procedure to ascertain what there is. If it's a case of giving the person written warning, then you have to do that.
Okay.
If it's a case of giving the person gross summary dismissal, then of course that might be the reason for terminating, because that might mean that it also goes against government another statute provision that tells you not to keep the employee. If the employee, for example, has involved himself or herself in issue, and the person is going to trial or is facing criminal charges, then you have to let the person stay away. Otherwise, you will also be in breach by
Okay.
keeping the person. So you do all that. But the key point here is, have you followed the process to end the contract? If the answer is yes, then it is conclusive that the dismissal was fair. If the answer is no, then it is conclusive that the dismissal was unfair. So the question is, what is your procedure for investigating misconduct? Did you follow? If you didn't follow, then that cannot be a fair dismissal. And the case law is clear. The reason why ACAS is involved is that we know ACAS is there for the employer and the employee. And they want to make sure that the employees are protected, much as the employers have the right to do what they ought to do. So if the employer does not follow the due process, then ACAS can be consulted to look into that. So ACAS requires that employers have to follow the processes to end the contract for employees. If they don't do that, then that could also be a breach. And such processes includes employers' own policies and procedure for terminating employment, either by conduct or by capability or redundancy.
Okay, Lawyer Asma, thank you very much. When it comes to employers and employees, there are a whole lot of stuff that goes on, especially when it comes to dismissing employees. Now, according to your submission, what ACAS can do, and then what the employer must also do. And when I come to like gross misconduct, of course, anything gross is liable to dismissal. But for instance, if as an employee, whenever you are being employed, you are giving employees contracts, and we call it employees handbook as well. We have employees handbook before even the contract. So there are a few things stated in this handbook where, as an employee, you're supposed to read everything within the handbook to at least fit into that new company you've just joined. Now, example of few things found in this employees handbook are some of these things as an employee, what you don't have to do and what you need to do. So, and when few things are also done, or when you do few things, what the employer can also do to you. So let's take it for instance, where there are some misconducts that an employee can, take in the within the company, and these few misconduct are not really termed or explained or even stated in the employee's handbook and even within the contract. So, in the absence of these few things, and then you find yourself in a situation whereby you've done something which actually is not even stated in your employee's handbook or even within the contract. And then the company is, or your employer is, basing on this conduct that you exhibited to dismiss you, and then you find it unfair because nothing, I mean, nothing of that sort is being stated in either in your employment or in your contract. So if you find it unfair, and within this stipulated book, two items that I've just mentioned, the conduct that you portray are not found in this contract, so you find it unfair. Where So how or what do you actually do? Do you go straight to acres, because to them they followed whatever due diligence, whatever the first may be giving you a warning, maybe verbally, which wasn't stated or written down. We know as soon as it's been written down, it becomes something binding. And then maybe the second time, the same verbal warning goes, because within the employment book, nothing of that sort. Like, if you do this, these are the procedure will go. These are the process you have to go before the final dismissal. So, in the absence of all these things, and then you have been dismissed, Loyasma, can you challenge or can you take it straight to ACAS with such a situation? And you think you can win to get back into the company?
So it depends on whether you qualify to bring a claim for unfair dismissal in the first place. The qualification, as we said, is 2 years as employee. An employee is defined under Section 230 of the Employment Rights Act. So you are an employee and you've been working for the employer for 2 years, then you have right in law. And your right is enshrined under Section 98, that you have the right not to be unfairly dismissed. Unfair means that the employer could not establish that the reason for your dismissal was fair in all circumstances, and that the reason was reasonable. So if the reason is not fair in all the circumstances, then it makes the termination or the dismissal unreasonable. And that's why we have to meet the reasonable test. So the employer, for example, will say that you have committed an offense. An offense is gross in nature, and therefore you cannot be allowed to stay on.
Okay.
The employer has to take steps to invoke its own policy for investigating such conduct or misconduct. So the misconduct will be spelled out, that the following misconduct will trigger dismissal. These ones are minor, and therefore they will lead to warning. These ones are serious or gross, and they will lead to summary dismissal. So those ones will be spelled out in the employee's handbook for the employee. There are other conduct which may not be spelled out, but they are implied. And therefore, if, for example, you have committed an offense outside of the company, and CPS or the police has taken over and dealing with it, then the employer has to step back and allow the law to take its course. In this case, you have to be suspended but then there should be investigation.
Yes.
And once the investigation is carried out to ascertain whatever happened, so whether it happened outside or inside the organization, there should be confirmation. And the confirmation will be after the investigation. So the employer has a genuine belief that this has happened, because the CCTV maybe has established something, but we are still not sure. So there's genuine belief, and the employer honestly believes that it happened. So genuine belief, honest belief. But the question is, did it really happen? And that will be after investigation.
Okay.
So we have to carry out investigation to confirm.
First.
And once the investigation is carried out and it turns out that it is true, then we tick all the boxes for reasonableness. So what is the reason for dismissing this person? And is this reason 100%? That's what we mean by reasonableness. If it is not 100%, then you cannot conclude that the person should be terminated.
Right.
So, granted, whatever act has that has occurred. But have you ascertained the veracity by your own systems and processes? So if you have confirmed by investigation and it is true that it happened, then you've established the genuine belief, you've established the honest belief, and you've carried out investigation. The three-tier test is met, and therefore you have met the reasonableness test under case law. The next thing is, can you then say that the dismissal is now fair? Yes, you, the employer, you have to defend the claim from the employee. The employee will say that you didn't do what you should have done to end my contract. And you will say that I did what I needed to have done. And what you needed to have done is the investigation. If the employee is still not happy, employee
Yeah.
will go to ACAS to complain.
Okay.
So after investigation, you'll be given your dismissal letter. And of course, you'll be asked to appeal if you are not happy. You'll be given right of appeal. So this week, somebody came to the office that the employer is terminating the contract because he has been, anytime he went out for a break, he returned very late. And it's been consistent for about 4 times. On
Okay.
4 occasions, he's returned late. And therefore, the employer believed that he was habitually unable to keep to his contract.
Okay.
And if that was the case, they had to do the investigation. And they had the investigation done. He attended the interview or the investigation meeting, and they gave him a right to appeal. So I said that, yes, you have to appeal if you believe that this is not fair. You have to appeal first. You cannot rush to go to court. So you have to do all the background work, including going to ACAS. So I told him, appeal, because you have 5 days to appeal. After 5 days of you appeal, after that, you get the feedback. They either say no, you are still terminated, or they will change their mind. If they insist that you are still terminated, go to ACAS. ACAS will stop the process and carry out its own investigation with the employer and come back to you. Once ACAS has concluded, ACAS is not a court. So ACAS is finding a way to resolve the matter amicably. If ACAS is not able to convince the employer to change its mind, then ACAS will come to you to say, now you are free to go to court to invoke the statutory provision. So from that point, you can go to court. The clock will start ticking. Actually, so if you want to go to court, the clock starts ticking from the second day that the act occurred. And the act is your dismissal letter or dismissal pronouncement. So whether you were told to leave or you were given a letter or email, that's the starting point. So the next day, you can take action. You have 3 months within which the action ought to occur, or you have to take action. Now, what it means is that within that period, you have to take action to go to court. What happens is that if you are going to court and ACAS has intervened, you have to wait for ACAS to finish. And we call it stop the clock period. So ACAS will pause the process. Because if ACAS is going to take, let's say, 1 month to finish, what do you do? So, so the clock will stop. We'll pause the clock. So once the clock is stopped, once ACAS finishes, we'll continue from there. Then you start counting again. Because it's very, very time bound. What it means is that if ACAS finishes and you go to court, it's up to the court to carry out its own assessment to confirm whether the dismissal was fair or unfair, relying on case law. The case of Norway and Anderson, the case of Accordius and Liddell, the case of Birchall, all point to the fact that it is not easy for an employer to dismiss if they are not able to show that there was fair reason in all the circumstances to terminate the contract for the employee.
Wow. Lawyer Asma, thank you very much. I know our time is fast spent, but this is equally important for us to, have this education as well, because it's happening almost everywhere. I get cases where people report to me, my employer said this, my employer said that, and stuff like that. Let me just give one example of what has happened. Lawyer Asma, you made mention now to timing. First of all, where the clock stops. So when you are being dismissed, where you feel or you think or you recognize unfairly, you have 5 working days to appeal. Is that right, well, Lawyer Asma? Is that
So the
right?
employer will give you time period within which to appeal, and that will usually be the employer's disciplinary procedure or policy.
Yes. So
So
it's not specific
so
like it's
each
this for.
employer will say that, right, you have 5 days to appeal, or you have,
Okay.
depending on what the policy is in place.
Right. So at what point where the clock, when the moment you give it to ACAS, that is where that timing that's the counting stops, or after ACAS before that timing stop, because it's a time
The
frame.
moment you give to ACAS,
Mm-hmm.
if you haven't involved ACAS, that means you are rushing to go to court. But it's always advisable. But even if you go to court, court will
Mm-hmm.
ask you, have you exhausted your rights
Mm-hmm.
within the work of ACAS? Because
Okay.
what the court is seeking to do is to avoid litigation. Because it's
Right.
very
Mm-hmm.
stressful,
Mm-hmm.
expensive, and time
Mm.
consuming. So the
Okay.
courts, with the best of will and intent, want to avoid people coming to them. So it will
Directly.
ask you, have you dealt with it informally with the employer?
Yeah.
Have you discussed with ACAS what ACAS can do for you on your by way of conversation with the employer? If you
Okay.
haven't done that, they will
Yeah.
ask you to go back and deal with that. But if you have done that, that means you've exhausted your alternative dispute resolution remedies, and you are coming to
The,
court of
oh,
litigation for remedy.
right. ACAS, you've mentioned ACAS several times. Lawyers, ACAS, is it a body that you can join with a monthly subscription, or is just there for every employer in case they find themselves in any situation like this, they can fall on to them, or you have to register with them and then it's like a monthly thing, you pay something to them like they are your future lawyers or something to do with like that.
Right. ACAS is a government body or organization
Mm-hmm.
that ensures that employers and employees have their rights protected.
Okay.
So they are free organization. Let's call it a charity organization that has
Okay.
the support or backing of the government,
Mm.
and they have a lot of support for employers and
Mm.
lots of support for employees. So all you
And-
have to do is to take a just Google their number, call them, and they will take you through the process.
okay.
As I speak to you now, there is a client or a potential client
Mm-hmm.
who is taking action against an employer for unfair dismissal.
Mm.
And the stage now is ACAS. So
Mm.
ACAS emailed me to say that the person's request has been received and they
Mm.
are going to look into it. At the moment, they are addressing the matter with the employer. And so once the outcome is known, they will come back to me so that we'll move on to the next stage of litigating it. So the aim here is to seek, if it turns out that they are wrong, then ACAS can ask them to settle you so that at least you move on with your life
Mm.
rather than going to court. But it's free. You don't have to pay anything. You don't have
Okay.
to subscribe. It's just like finding anything from any search engine. So search ACAS, ACAS, and
Yes.
you have lots of free information, including their telephone numbers.
Thank you, Leah Asma. Thank you so much. Our time is fast spent, even though there are so many questions coming up whilst we are having that discussion. All those on board, thank you for coming and thank you for joining us. Let me just acknowledge some few people and then we can move on to our next segment of the program. So, Citizen Kwejo says, good evening to you all, citizen. We respond to your greetings. Then we have Sandra Fraser. Oh, sis, how are you doing? Say good evening, fellow viewers. Please share when you join. We appreciate your support. Indeed, you need to share this program because it's not just for you and I, it's for everyone. So take it upon yourself and keep sharing, liking the page, and then subscribe to our YouTube channel and our Facebook. You say when you're watching us on Facebook, please, one thing you can do for me, just the like and the love button, stop clicking on it, click until you're exhausted. Bernard Owusu, hello, says hello. We respond to your greetings. Hello to you. Adai Mununkum. Hey, Wafa, how you doing? Say good afternoon, everyone. Please share the show when you join. People are really, into this, and they are telling everyone to keep sharing because of the authentic education that we have on this platform. So, say Sanders Photos for Jam. Say good afternoon, everyone. Good afternoon, sir. We respond to your greetings. And my dear Sister Dorcas Adom, you say hello, Lawyer Charles and bro. Today, in place of our brother Peku Ureku from Ghana. Don't worry, sometimes we have to interchange few things. So yes, I'm here instead of our brother Kweku Owusu from Pong. Hello. Wumpune Adams, a champion BF Solicitors. Indeed, we are champions because when you look at the number of years we've been in existence and the success rate that we have, oh, of course, we are champions. Tilly Duma, hello, lovely family. Hello, sis. How are you doing? I said, please kindly share, comment, and like. Go on, everyone coming on board. Continue to share the program, continue to like the program, and then go on to YouTube channel and subscribe to BWF Solicitors website, and then the Facebook and the YouTube as well. Good afternoon, Kevin Asamoah. Good afternoon, Manye and Lawyer Asma. Good job. Thank you, bro. Thank you, wherever you are. Thank you. So let me just pause here because time is fast spent and we haven't even come to our main topic for today. But Lawyer Asma, before I do so, there's something that really concerns me. I might even ask it during or after the main topic education, but this person keep bothering me. So let me just quickly, since it's just one of the questions that came out during our employment education. This person came as a skilled migrant worker, and she came with pregnancy. And in fact, surprisingly, this pregnant has it's like almost 9 months already. How this person beat the immigration and then came, only God knows. But she came just few weeks and almost due to go and deliver, even has not even reported to the employer. So when she called the employer to notify her of her arrival, and then she, had to pass the information to the employer that, oh, sorry, I came with pregnancy. So from the look of things, I'll prefer to give birth after I can start working. So the employer said, well, you should have informed me because during our process of interview and stuff like this, like that, you didn't state or you didn't actually give me that information. So first of all, it looks like you've deceived me. Your employment or your CV or whatever was based on deception. Sorry. So I'm not going to accept you and I'm terminating your contract as of today that you've spoken to me. Lawyers, man, this person came crying and saying, why would the employer dismiss her because of pregnancy? But then, during the explanation you gave us, you made mention of 2 years in employment. So let's see how this work within that 2 years. Is this dismissal going to be unfair or fair, Lawyer Asma?
I mean, we have to be clear and objective as well.
Mm.
You came into work.
Yeah.
If there has been anything without the fault of the employer that prevents you from working, then that will lead to, or that will trigger termination anyway.
Okay.
Because you have a probationary period. And within that probationary period, if your conduct or anything creates an impediment
Yeah.
to the extent that you cannot keep to the side, your side of the contract, then a sensible employer will tell you that we have to end it here.
Okay.
To the extent that you didn't even tell the employer that there is contemplation that you cannot do the work once you arrive. There was contemplation because she knew that she wasn't going to be able to start because of pregnancy. So did you deceive the employer to believing that you were okay? And if it's the case that you can't do the job, then somebody else has to step in. So the
Yes.
employer wouldn't be wrong to say that we have to end it. That's one point. The second point is that in terms of bringing action, you don't qualify because you haven't worked with the employer for 2 years. So the qualification period is not ticked off.
Okay.
Yes, you are an employee under Section 230 definition, but do you qualify in terms of continuous 2 years work? No. And is it the employer's fault that they say no? It is not their fault. It's your fault. You have a claim in law? No. It's up to the employer if they can help you in any way, but they have no duty in law to keep you.
Well, thank you. In that case, that's the end of the case. If my producer is still there, please, can we have a quick commercial break? As soon as we come back, we'll commence with today's topic. We'll be right back.
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214-218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
Welcome back. This is the Community and the Law, and your favorite host today. I'm here. Manyanate is my name. So far we've discussed so many things earlier on concerning employment law and unfair dismissal. But now we have our main topic, which is, if producer can put it on board for me. There are occasions, there are so many cases that when you come to abroad, or when you visit abroad, let me put it that way, one or two reasons you get to be banned from re-entry into that particular country. And for that matter, we are talking about UK. So today, we are going to investigate or talk few things or just educate ourselves about how to challenge a visa ban within 28 days and have it removed. So what it is, Lawyer Asma will come and educate us on that. But then let's look at the circumstances around it. Sometimes, why do we get banned on visa? Sometimes what happened, actually some people even have the visa, and then when they get to the airport, then they ban their visa even from entry. And then some people also, they might be in the country already, and then one or two things may happen, and then their visa get terminated, and then they ban them from re-entry. So today, Lawyer Asma, we have this big question in front of us. In case I fall within any of the categories that my visa will be banned, first of all, why would a visa be banned? If you can, we can start from that point.
Thank you very much, viewers and listeners. Pleasure to come your way once again. And thank you for making time with us. Um, Today's conversation is about a ban. And well, let me quickly re echo the celebration that Lawyer Annie is one of our hardworking trainee solstice. And this week, she celebrated the good tidings of God. So, Annie, wherever you are, be rest assured that BWF Solicitors is with you every step of the way, and God is with you more. Congratulations. Right. So we are talking about a ban. A ban is a restriction imposed on anyone who wishes to enter the UK. We are talking about UK. Who wishes to enter the UK? And the reason for the restriction might be that the person has told a lie, and therefore their conduct is no longer acceptable. So they are restricted for 10 years. That is called statutory ban. So that's the simple explanation. So preventing somebody from entering the UK for 10 years because of something they did within the immigration rules. So we are going to look at the things that may trigger that, because we said because of something they did. We have part 9 of the immigration rules. Part 9 of the immigration rules deals with conduct. Conduct here, we are looking at what you tell the caseworker when you are making a visa application. When you are making an application, you are giving application form, and you have to tell whatever you want to tell or write anything you want to tell them. Your name, your date of birth, in other words, personal information, immigration history, family information, reason for traveling or making the application, and anything else you want to say. So your personal information is your personal information. But the point is that nobody can challenge you for your or about your personal information. So if it's changed and you are giving new ones, it's fine. And therefore, I don't think anybody will pick you up on that. We are also looking at your immigration history. One of them will be that you have made applications in the past and you have disclosed information to them. You are making application again and they're asking you to disclose information. Such information might have a bearing on the previous application or previous application decision. For example, within the application form, you will be asked, have you ever been refused a visa to any country in the world, including the UK? This is a yes or no question. So the answers are yes or no, and you have to select one. If you select no, and it turns out that they know that you have been refused before, then you have concealed information. Because the fact is that you have ever been refused a visa before, especially to the UK. True or false? True, because they have it. The fact
Yeah.
that you forgot does not make it better.
But, well, I
Because
ask, hold on 1 minute before you continue. You know, whenever they ask these questions, sometimes they put a time frame and sometimes you don't see the time frame. And when there is this time, 10 years gap, and they ask you, have you been refused in any country within the last 10 years? And probably you've been refused maybe 15, 20 years before, and if you are not sure and you put yes and you can't remember the date, how does it affect you? Or if you put no, which of course not within that 10 days, 10 years, 10 years, and it's been maybe 11 and over, and you didn't stay that, and they find out that you've been refused within these years, would that also affect that particular visa?
So there is a general question and specific question.
Okay.
The one I asked, from what
Mm,
I know from the application forms,
mhm,
is a general question. Have you ever been refused a visa
mm,
to any country in the world or UK? They don't add any time, and therefore it's up to whenever. So if
okay.
you have ever been, you have to say yes.
Right.
The next question, possibly, it's not often the case that they will add the time, but they add the time that in the last 10 years, have you? Then you have to check. If it is more than 10 years, then of course your answer will be no, because in the last 10 years, you have not.
Mm,
But if the question doesn't specify it, then
mhm.
it's for indefinite. So you have to say yes if it's
Okay.
ever happened before. It's always
Okay.
the case that it's an open question or general question, and therefore you are expected to say yes and give the answers. So
Okay.
let's say you know you have been refused before.
Mm,
Then you say yes. It will ask you to provide the details. That is where you can put assume date and circumstance there. At least, if the date is gotten wrong and the description is wrong, it doesn't change the fact that you have admitted yes.
okay. Okay.
Otherwise, the best thing to do is to make a subject access request application to the government requesting for your file so that
Mm,
you can refer to and provide definite responses to the questions where you are in doubt.
mm,
Right.
yes.
So that is the first point.
Mm,
The representations we make on the application form. Once the representation turns out to be false, we say false representation. What it means is that you did that with the view to take immigration advantage, and
mm,
that is misrepresentation, and that's a breach of the immigration rules, part 9.
mm,
We now move to anything else which is not on the application form. Document you submit. So the first one is the information you provide on the application form. And the
mm,
next thing is the document you provide with your application.
mm,
Once the document turned out to be fake, I will use the word fake. We usually polish it and say misleading, false, not genuine. But it remains fake.
mhm,
Once the document is fake, they will pick that up if they
mm,
have done their assessment. Sometimes they will say, we have checked. It might be the case that they haven't checked, but they will say they have checked. But whether they have checked or not, once they say that the document you have provided is not genuine, then what they are saying to you is that you have breached part 9 of the rules, which says that false representation, including provision of false documents in support of your immigration application. So, what are some of these documents? One, birth certificate. Two, employment contract, including certificate of sponsorship. Three, anything else, bank statements, and so on, pay slips, and all that. So what we are saying here is that we have to make sure that they are genuine. How do you show that they are genuine? Once it's coming from the original source, even if they doubt it and they go to check, they will find out that it is genuine. And even if they ban you and you are challenging it, you get a letter from that source to confirm that it is genuine. Then you can use it to win your argument to challenge the ban. But these are the two reasons why you will be said to be in breach of Part 9. False information on the application form. If they find out that they are false, you'll be refused. I will come to the basis of refusal later. Or false information, false documentation that you add to your application. If it's indeed false, and they find out, they will say, because of that, you are refused, and a ban is placed. We'll come to that. So that is the basis. We mentioned certificate of sponsorship. We'll come to that because that will be part of the conversation for today, based on the experiences we are having so far. So these are the two reasons. Now, if you look at Part 9, there are two parts to it. So once you are refused under Part 9, you are either refused under paragraph 9.7.1. 9.7.1 is a discretionary refusal, which will say that you have been refused under this. That will not trigger a ban. But there's also a mandatory refusal, which is 9.7.2, where they assure that you have used false information or false documents, and therefore your refusal has been mandatory or compulsory, automatic. And because of that, it triggers a ban. So the rules say that if you are refused under paragraph 9.7.2 of the immigration rules, you will be refused in subsequent applications for 10 years. In other words, any application you bring, once you are refused under point 2, 9.7.2, if you are going to be bringing new application, whether visit, whether family, whether work, whether student, it doesn't really matter. Any future application you make to the UK embassy abroad will be refused automatically. And that will be noted on in your refusal letter. So 9.7.2 will trigger 9.8.1, 9.8, and others. That means you are banned for 10 years. And once they tell you that you are banned for 10 years, you have to take steps to remedy. Otherwise, it stays with you for 10 years. That's the conversation for today. We have a resource to use, a refusal that came through, and how it was couched, or how the reasons were set out, referring to paragraph 9.7.2 and referring to paragraph 9.8.1 and others. So if the producer is ready, yes,
Yeah.
that will be shown.
Okay.
So thank you for the one who provided this resource to us. We are grateful to you for sharing this resource with us. This is for educational purposes only, and therefore we have taken steps, due care and attention to remove anything personal, including name, date of birth. So this is for education purpose only, with the best of will and intention. So the date is 14th of November, so you can see that it's fresh. Because today's date is 18th, isn't it?
Yes.
Yeah, so 4 days ago, literally, or 5 days ago. Since you applied for skilled worker migrant visa, health and care on 3rd of November. So you can see that this visa application took about 11 days to be decided. I am writing to tell you that you have been refused, full stop. And what it means for you is this. Then it takes us to the reasons for refusal. Why have you been refused? You have been refused for the following reasons. Reason number 1, your application falls for refusal because it did not meet paragraph SW 2.1. SW 2.1 is skilled worker migrant program, or skilled worker provision, which talks about suitability. And that's the equivalent of Part 9 of the immigration rules. If it is a child, it will be SW 27 of Appendix FM dependent. But this is Appendix skilled worker dependent. But this is Appendix skilled worker main applicant. So SW 2.1. It says that you cannot meet the suitability requirements under SW 2.1. And you can see that if your application falls for refusal under Immigration Rules Part 9, that's the grounds for refusal. So these are just borrowed words or borrowed rules. So Part 9 is the general rule. If it is about skilled worker, they will say 2.1. If it is the skilled worker dependent, they will say SW 27. If it is a student, they will say S something else. ST something else. But if you go down to paragraph 1, 2, 3, 4, it says that I have considered the facts of your application with reference to paragraph 9.7.2 of part 9 of the immigration rules. And that establishes that an application must. The word is must. Must is a mandatory word in law. Must means compulsory. It must be refused. If they say may, then it is discretionary, and that paragraph will be 9.7.1. But if it is 9.7.2, they will say must. The moment you see must, you know automatic. So it says that you must be refused where the decision maker can, and the word is can prove it is more likely than not that the application was made with a view to deceive, or the applicant used deception in support of their application. What is the deception? The information on the application form and the supporting document you added will be the causes of such deception. In other words, a lie, simply, to deceive. So we are looking at that paragraph. In submitting your application and giving the basis, in submitting your application, you have confirmed that the supporting evidence is correct. Because remember, when you are submitting an application, they ask you to tick the boxes to say the information you are bringing, to say whether you agree that they are genuine, and for you to sign. You know that? So they are saying that in submitting your application, you have confirmed that the supporting evidence is correct to the best of your knowledge and belief, whether they were submitted by you or on behalf of, or on your behalf by a third party. A third party is anybody apart from yourself, and that includes your lawyers. Now, in support of your application, so these are the facts. You have submitted a COS, defined certificate of sponsorship, which confirms your name and relates to you with a reference number redacted. I have searched Home Office records and I have established that this reference number corresponds to a different certificate of sponsorship. In other words, the same number is on a different certificate that has already been used, which relates to another individual. And because of that, I am satisfied that you have submitted a false document. So this person did not make false representation, but used false document in support of the application. This document states that you are a genuine, you are being sponsored as a skilled worker, given that a valid defined COS is a mandatory document or requirement under Appendix Skilled Worker. I am satisfied that you submitted this document with, and the word is intention, with the intention to deceive. So we have to establish, if we are going to challenge this, whether there was intention to deceive. Because it might be innocent misrepresentation. So if it is proven to be innocent, then we can force them to change the wording of the refusal letter from 9.7.2 to 9.7.1. Or 9.7.1 is a friendly refusal that does not trigger mandatory ban. After considering all the circumstances of your case, I am satisfied that on a balance of probability, in other words, putting all things together, I have concluded that you have used deception. It is likely to conclude that you have used deception in support of your application. As a result, your application falls for refusal under paragraph 9.7.2 of the immigration rules, and that's the grounds for refusal, part 9. You should note that because you have been refused under 9.7.2, any future application will also be refused, and the word is will, compulsory. will also be refused under 9.8.1, 9.8.4, 9.8.7, and so on and so forth. We are not going to go through those provisions, but suffice to say that if your refusal is mandatory or compulsory, then future application will be refused compulsorily for 10 years. Therefore, your next application can only be made after 14th of November 2033. It didn't say that, but it says that you are going to be refused automatically up until 14th of November 20, so that's 10 years. Next steps. Because this is appendix skilled worker application, you do not have right to administrative review. You do not have right to appeal, and therefore you can apply for administrative review to have this decision reconsidered. And that is the conversation for today. How to challenge a decision under 9.7.2 and have your mandatory ban challenged or removed.
Wow. Lawyer Asma, thank you. Oh, what a sad one, of course. I'm really surprised, that the Home Office can go to that extent, checking everything into details and then probably coming out with such a decision. And of course, if the decision was based on the certificate of sponsorship that is being used already, and this person was being issued to support the application with the with the new visa application. Of course, it's something that we really have to look into it. So, Pastor, I'm sorry, Lawyer Charles Asma. Now that this thing has been given out, we've read whatever the decision and the explanation of the 9.72, and then that will lead to 9.8, 9.81, 9.8, and so on and so forth. All these categories, actually, we don't even know what they are, but all we know that it's the final destination is that you are banned for 10 years until you can make a new application to be considered. Lasma, today's topic, we are looking at how we can challenge such a decision. That is our main thing for today, how we can challenge such a decision. Now, the Home Office have given you 28 days to do that. And this is administrative review, no more appeals, but administrative review. So, Lawyer Asma, where do we start from if we want to challenge such a decision?
Thank you very much. Now, deception is an indictable term because it touches conduct. Because somebody is telling you that you have used lies, that means you are a liar. And that's conduct. And because it's conduct, it can be detrimental to your emotions and everything, especially if somebody is accusing you falsely. So this is an allegation that you have used deception.
Okay.
The first question is, do you agree?
Okay.
If you agree, that means you don't have to do anything. If you disagree, then you must do something. But I believe that if it was the case, maybe you wouldn't have done it. And therefore, on a balance of probability, it is not the case. And that is why you want to challenge it. So you disagree that you have used false information or false document with the intention to deceive. So the key word is you have used it with the intention to deceive. So the fact that there's action, the actor's race, if it is a criminal thing, we are looking at action and intention. So deception is a mental thing. It says intention. So did you intend to deceive? And it has to be proven. How do you prove intention? It's a matter of assessment. So the fact that the action is committed does not mean that it was committed intentionally. And therefore, case law and Home Office guidance and provisions require that once there is allegation of deception, that touches on the conduct of that person or the applicant, they have to prove it. They should have given this person minded to refuse notice, to explain or to clarify matters, but they did not. So this person will have to challenge this. We are looking at the case of, for example, Belajigari. The case of Belajigari says that in making an assessment or conclusion to the effect that somebody has used deception to take immigration advantage, you have to be sure. And how do you prove that you are sure? Whatever evidence you have found, you have to use it. And you have to draw the person's attention to it and ask them to challenge it. This person should have been given the mandate to, and I should say that this is the second refusal that has come through in a matter of a month, about 6 weeks. So what we are saying is that you have agreed that it is not the case. You are going to challenge it. So you put them on notice by way of completing your administrative review application. But you must have your evidence. They are saying that you use fake COS. But you are saying that, or your case is that you applied to them you applied for the job, the employer gave you the job, give you the offer, issued the COS to you. You have your documentation as part of the recruitment process to support your claim. That means if it is true that it is not genuine, then you were taken advantage of by the employer, not even you. Because you are an innocent employee, prospective employee at the time. And you couldn't have known that this has been used or this is not genuine. How do you assess a document of this nature? So you have to, so more or less, you are an innocent victim of circumstance.
Yes.
And if you are innocent, then the refusal should have fallen under 9.7.1 and not 9.7.2 because there's no intention attached to the conduct. So how do you show that you did not intend or you have no knowledge of this? Letter from the employer confirming that yes, it was issued genuinely. And your processes, documentary evidence confirming the processes you followed through to have your job offer. If all these things are there, then you will conclude that I didn't know about this. Yes, the law says that whether you knew about it or you didn't know about it, but because I did not know about it, that makes me innocent. And if I'm innocent, then I do not have intention because innocence does not have intention attached. So you have to show that you acted innocently and you should support your case with evidence. What I have said.
Okay.
And once you put in this, they will revise the decision and move it from 0.2, that is 9.7.2 to 9.7.1. For 9.7.1 says that you may be refused.
Yes.
And 9.7.2 says that you must be refused. That means you are going to be refused because you caused this act or you acted this way deliberately. But if it is proven that you didn't do it deliberately, then they will reissue the refusal notice and remove the ban and leave it at 9.7.1.
Right. Okay, Lawyer, thank you so much for that explanation. So even if after that ban is being refused, is there any way they may reconsider to give you the visa again? Or since they've realized the COS was a fake one now, are they going to deal with the company involved here? You know, why the company should offer or issue you with such COS? Is there anything like that, or is just up to the home office people?
Well, I don't think that is a matter for the applicant to worry about.
Okay.
The applicant worry is how do I tell them that I had no knowledge about the fact that this is not genuine.
Genuinely.
And that
Okay.
is what you seek to do. What they do with the employer, I don't think you have to worry. If you have to worry, then you don't want to do anything at all.
Okay. So lawyers, okay, in that case, if we are being issue with the COS, I mean, I'll come to my next question, but genuinely on this particular one, because we are using that as an example. So if you are giving this COS as an employee, is there any way you can also verify or check? Is there any system, anything at all? Because sometimes I know to get to know the genuineness of the company, of course, you can go visit the company house, see if that companies really exist and stuff like that, when they were established and things like that. But when it comes to issuing of that particular license, that will enable you to obtain your visa to come. And for instance, maybe there has been some few what do you call it, you've already, you'll be paying for your skilled migrant visa. You'll be paying, there will be few amount of money that will involve when you are applying for the visa. So in order to protect this visa fee, your skilled migrant fee and COS fee and stuff like that, do you have anything that you have to due diligence, you have to confirm or to establish that genuinely this particular COS is, of course, what it says it is, or there is nothing like that for the employee to do so? When you receive the COS, straight away you have to process your visa, and then you wait for your approval to get the visa. Is there anything like that?
Now, I mean, what it is
Mm-hmm.
what we see.
Okay.
We
Okay.
see somebody who is applying for a job.
That's it.
We
Okay.
see an employer who is ready to offer a job.
A job. Okay.
We see a careful and competent applicant.
Hmm.
The word is careful
And
and
competent.
competent. What it means is that if you are careful, you want to make sure that you are dealing with the right employer.
That's correct.
If you are competent, you know that you are not putting yourself at risk. So if you are competent and careful prospective employee or applicant, and you have done your checks, I doubt if you'll be able to confirm that the employer is dealing with the government correctly. You
Okay.
can't. How do you confirm that the government document given to you is not genuine?
Okay.
But it is up to you, because it is your case. Because you are saying that you have applied for a job and you
That's
are dealing with this employer, and this employer says that they have made an application in your name to get sponsorship for you.
all right.
Between the time the sponsorship is issued and the time you made your application to the Home Office, it's an assessment period.
Right.
Because the caseworker will check to see whether the employer actually got it from them.
Yes, I
And
asked.
you will.
Sorry about that for that interruption. I asked this particular question because if the Home Office is placing that ban on me, and now we are going to administrative review, just standing in that gap, that would there be a situation where during that review I'll be asked whether I took the due diligence to ascertain or assess the COS that was issued to me before I even made the application? That was the main reason why I asked this question.
It is not the assessment of the COS.
Okay.
It is the
And
fact that you went through a genuine process
right.
to be offered the job,
Okay.
leading to the sponsorship. So you cannot assess whether the sponsorship certificate is correct or not, because it's just a paper. The employer is the one telling you that everything on that paper is correct, isn't it? The question is, do you doubt the employer? If you doubt the employer, then you have to pause and check. If you don't doubt the employer, then you will innocently follow the employer. And if it's the case that you innocently follow the employer, we want to see the processes you went through to get the job and the sponsorship. And that is what you are going to rely on to make an application that I have used the information innocently because I relied on what the employer gave me. And if it is proven that you could only be innocent for or from you using or you receiving that document, then they will consider to change the content or the nature of the refusal decision.
Right. That's okay. Let us is there any way somebody can represent himself during the administrative review without getting a lawyer? Because you see, when it comes to this terminology, we know, of course, when you involve a lawyer, it also involves you have to pay the lawyer to represent you during such cases, and this is a massive thing that indeed you cannot do it yourself, or probably you can do it yourself. This is a ban, 10 years ban, and we are fighting for it to be reduced to a normal discretion. That will make you, can apply for other visas in future before that 10 years or even after the 10 years. So will you advise when it comes to such a thing, or when you get a refusal letter like this, you ask for the assistance of a lawyer, or you can something that you can straight away do it yourself, because proving your innocence sometimes, you may not even know the kind of documents you should use to support. Now we've gotten it from you that you can use the process that was obtained by, maybe there might be a Zoom interview, there might be an offer letter, there might be some assessment, there might be some, whatever process, that normal recruitment process that you have all this evidence to show. But in case you are not able to, would the lawyer still be able to assist in this way, or you have to get the lawyer? I don't know if you get my question.
Yeah, I got a question very, very well. Now, let's work together on this.
Mm.
Do you believe in self-medication?
Oh, but lawyers.
You wouldn't advise, will you?
Yeah, I would say yes and no,
Well, you
because
say that when you are genuinely ill, go and see a doctor.
that's it.
That is your professional advice anytime. And I know
Oh,
you,
yes,
that you,
yes,
you say that.
yes.
What it means is that if somebody is in need of legal help genuinely, then they have to see a lawyer
A lawyer.
because they got it wrong for doing it themselves. Then why are you going to get it wrong the second time?
Of course, of course.
So if you get a doctor to treat you when you are genuinely ill, then get a lawyer to help you when you are in genuine need of legal assistance. That would be my position on this. But it's a call for the individual. Individual will have to decide whether they need a lawyer for this or they want to do it themselves. Maybe they will try again now and later come to the lawyer. That will even make it more expensive and time consuming.
And time consuming. Thank you very much, Lawyer Asma, for that explanation. The time now is 5:36, and we are still here. I will open the telephone lines in case what we are discussing you want to ask a question. However, if the question that you have as of now is not really regarding to what we've discussed, you are still free to ask anyway. Lawyer Asma is an expert and will be able to answer any question when it comes to legal matters. So if you've just joined us, we are here. This is BWF Solicitors, the community and the law. And what are we talking about? How you can challenge a ban on your visa when you've made an application. And we know from the beginning, we did talk about a few things on employment and visa, employment and unfair refusals before we came to this particular topic. Whatever issue you've got concerning anything immigration, anything family matters, family law, anything litigations and stuff, and even Ghanaian law, you are still okay to ask if you have such questions based on these areas. Where we are now, very soon we'll come to our normal, is it what we call it, the quiz, BWF Solicitors, community and the law. We always have a quiz after or getting to the close of the program. And I believe this quiz will base on the initial explanation that Lawyer Asma gave to us. But the telephone lines is now open, 0208 123 1016 or 073 9920 8468. So you can call Let me see if the lines are really working now. You can call to ask any question at all, and Lawyer Asma is here to respond. But whilst we are waiting for your calls, let's have just a small commercial break whilst we upload some few documents, and then we come back. I'll be right back.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate, or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the interstate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.
Okay, welcome back and thank you for your patience. We have a caller online. Hello, my dear. Where are you calling from? Let's hear from you.
Hello, good evening.
Good evening.
Hello, I'm calling from Milton Keynes.
Okay. How
Hello.
may we help you tonight?
I've got two questions, if that's okay, but they are linked. So
yes, that's okay. One moment. Let me see if my lawyer can hear you. Lawyer Asma, please, can you hear our lady on the line?
Yes, I can.
Thank you. Please go on.
Okay, thank you. So I'm due for naturalization. So I got my indefinite through the EU route, and it's 1 year already. So I'm preparing to do the naturalization. So I've got the life in the UK, and I did a master's degree here. So I've got an English, and I've got that one to use as the English. My first question is, when you're doing naturalization, is there a need for a cover letter at all in terms of explaining any situation maybe you might have gone through? I'll explain why I'm asking that, because previously I was refused. My previous application was refused, and the reason was being that they said that I was involved in like marriage of convenience.
Okay.
However, that was not proved by anybody. I got refused, and then I went for an appeal, and the judge dismissed the appeal and said that there was no evidence to suggest that my
marriage was
due. So I went through my Zambrano, and I got my indefinite leave now currently. I do a lot in the community in terms of charity work and community work and all that kind of thing. My worry has been around the character thing, which they now said you could apply 5 years, but then when you have issues around this kind of allegations that can withhold that can take you through the 10-year route. So that's why I asked the first question, that do you need a cover letter that can explain the circumstances and then what you've been doing and sense and all that, or is it not relevant?
Oh, okay. And Lawyer Asma will answer you in a minute. But what I know when it comes to applications like this, I know there are a few questions that they might ask on the application whereby you have to state yes and no, of course, just as we explained from the beginning. And when you have to, after I think getting to the end of that application, there are spaces that provide you to, give whatever any additional information you want to give. That is what I know. But our expert is here. I don't want to take it from him. Like Asma, please, can you answer our sister a better explanation than mine?
Okay, so if you feel that you need to clarify matters to the caseworker, then do it by way of attached letter, or you can use the additional information box that comes at the end of the application form. That gives you about 500 words. So it's a choice. It's not a requirement, but it's necessary to make your point clearer.
Okay. And do I need to, so for example, is it necessary to have a letter from like the organizations and the charity work that I do and all that, or it's not necessary?
What for?
So I'm looking at, when they talk about citizenship and all that, the kind of things that like if you're doing for the community, and because I remember when I was doing the line.
I understand you, but why will you need those letters? What is your reason for wanting them?
And so in terms of the character part, because I started by saying that when they put an accusation like that on you, it's like the character bit, requirement bit is still hanging on you.
Yeah, but when they said you have been engaged in sham marriage, did you go to court?
Yes, I did.
Yes, she did.
And did the court say yes or no?
The court said because
was the appeal dismissed or allowed for you?
Ex-husband by this time. The fact that he wasn't there meant that so they will agree that it wasn't a genuine marriage. But it was just that this individual wasn't there and wasn't prepared to come to court.
So eventually you went to the Zambrano route. But the point I'm making is that is what they thought, but it doesn't make it true anyway.
Right.
So if somebody makes an allegation that, because truthfully, you married your husband with the best of will and intention, didn't you?
Yes.
And that is what it is. And nobody's going to raise that when you are making a naturalization application. Suitability has to do with criminal conduct, has to do with breach of immigration rules, to the point that it is very serious as to be allowed to remain in the UK as a citizen. If it's a matter of, for example, you are owing NHS because you were not supposed to have for free and you had it and you were given a bill and you didn't pay, those are the things that they will be picking up. But your private life matter, marriage, if they say it's not a genuine marriage, well, and so what?
I know she's all right with that. Thank you very much. Yeah. I hope you are answered, my dear lady.
Yeah, I am.
Yeah. Have you shared our program anyway?
Sorry?
Have you shared our program?
Those I know are all watching at the moment, so I haven't gone anywhere.
It doesn't matter. Go to Facebook, share on your platforms, pick it up and then share on your WhatsApp groups, any group that you belong to. I believe it will be beneficial to a lot of people. Okay.
Right, thank you. Bye-bye.
You're welcome. Bye-bye.
Bye.
Yes. It's just about under 50 minutes to the hour 6 o'clock, where we'll bring a curtains to the program. But we are still here. Our quiz will come on soon. The numbers again to call is 0208-123-1016, or you can call 073-9920 8468. If you have any WhatsApp questions that you want to, if you have any question that you want to send through the WhatsApp or not on the platform, you can send it through 075-966-20154. I have a question here, and okay. Right. Derek Yabua has posted a question on board. Let's see if I can see properly. Say hello, Manye and Lawyer Charles. Fantastic explanation. Please, I would like to know, as a student, if I have a child with my dependent partner, does our child automatically get our visa, or we will have to make an application for the child? Thank you. That's the question. And there is, I think, Yes. Lasma, can we answer that first before the second question?
So everybody must make a visa application before they can get a visa. So if they decide to apply for the child because they are planning to travel or they are planning to go on holiday while still studying or in the UK as students and student dependent, they have to apply for the child. They can put in the application here in the UK for the child to be given what they have.
Okay. Thank you. I believe he's listening, so he'll get the answer. Now, he said, my second question is to you, my dear Manya. Oh, okay. I applied as a student to study masters here in the UK. I didn't have to write IELTS because I used my degree from Ghana. I want to register as an international midwife with the NMC. One of the requirements is IELTS. My question is, do I have to write the IELTS or have the way I can use my degree from back home to in order not to write the IELTS? And if I have to write, do I have to write the IELTS or a different English test will cover that? Thank you. Of course, to me, yes. Unfortunately, when it comes to UK NMC, they don't accept your degree certificates as a basis of your English proficiency. So what it is that you have to write the IELTS again. But we have two types. When it comes here, you have the chance to write two types, and of course, the one that is mostly they prefer. I won't use the word prefer, but when you use that one, it's more likely is straightforward as accepted is the OET, because that one is based on occupational health test. So, sorry, occupational English test, sorry. And that is what we call OET. If you need any assistance in doing that, of course, I'm here. Katie, Consult Education, we offer OET classes every Mondays and Wednesdays. You can join. We can take you through most of the questions. We can take you through the process. It's just similar to the IELTS, but it's basically or medicinal or medical or hospital or whatever base content as compared to the normal IELTS exam. So I believe I've answered you. And yes, you need to write the OET to add it to the English to your application to get your NMC. Yes, so our time now is just almost, this is our quiz for this evening. Test your knowledge, and we've got these online for the past week. So I believe after reading this, the answer should be straightforward to you. And based on the explanation Lawyer Asma gave earlier on, you should be able to get this one right away. So let me take it. Isaac worked for a supermarket for 10 years. Isaac was dismissed for gross misconduct because he had removed some bakery items at the end of the day and applied the waste not procedure to the bakery goods. This was on the basis that the items would have been written off and disposed of at the end of the day. So he decided to let himself and his staff buy them as a discounted rate. He complained that his conduct was minor and he shouldn't have been dismissed. What is likely to be outcome of his appeal? So we have, if Oreku is say Pampana, we have the possible answers that you can choose from. So we have one. The decision is dismissed. Sorry, the decision to dismiss him was unfair as it was not reasonable. Second one, his behavior was gross misconduct and his dismissal fair and reasonable. The appeal will be dismissed because he stole from the business. Pampana, so read the question, read the whole case again, and I believe you can detect the correct answer from the explanation Lawyer Asma gave earlier on from the start of the program. Pampana, so let's see your answers coming up. All those watching us live, let's see your answers. Derek Yabua, thank you so much for that prompt answer. Let's see, Dorcas, we are waiting for you. Sari Fraser, we are waiting for you. Sandra, we are waiting for you. Your answer, Tilly Duma, my dear says. Let's hear from you. Let's hear from you. Let's hear your answers before Lawyer Asma comes into play. Last, whilst we are waiting for the possible answers, the viewers are bringing in. I have a quick question. Let's ask this one. I have a quick question. When it comes to unfair dismissal, sometimes is if you don't understand the law, that is where you are always taking you get surprises in your life. Adam Nukum, thank you for your answer. You are saying number one. Derek said number one. Wow, the decision to dismiss him was unfair as it was not reasonable. Who else? Who else? Let's hear you. Let's see. Yeah, let's see the answers. Let's see the answers. Let's see the answers. Okay, Lawyer Asma, if somebody has applied for this co-migrant route, to come to as a worker to come to the UK. The application has successfully gone through, met all the requirements. I mean, everything has, even the person was refused before, but not 9.72 though, just 9.71. And all the evidences or the reason for refusal has been really, um, obtained and then said on the application form. But the application has taken more than to get into 3 months now. So what would be the problem, or what do you think this person should do, to chase up Home Office? What is happening? What can the person do, Lawyer Asma?
Well, the person can email them, but I don't think 3 months is doom and gloom. They can wait, but of course they are coming to work. They have time frame within which to arrive or report.
Yes. Yes.
So if they did the priority, I'm sure the decision would have been made. However, it might be a genuine delay by operational bottlenecks. So they can email them to say that they are chasing, or they have not had or received decision for 3 months since they had their fingerprint done. Then yeah, then they can wait to hear from them. But I mean, I won't sit here and say that when they do that, it will change anything. I mean, I have to be objective and fair. We are receiving volumes of requests that my application has delayed.
Delayed.
And we always tell them that it is happening because there is a backlog and there is huge
Backlog.
work on them. There isn't enough workers compared to the volume of work they have to deal with in terms of decision. So I won't sit here and say that, oh, when you do it, you should receive the decision. But I will sit here and say that let's manage the expectation. So email them, but expect that they haven't come back because they haven't finished with your application. But email them and see what they come to tell you. But what I know is that there is huge delay and backlog.
Thank you. We are still here. I have another question coming from someone. He said, yes. I don't know if it relates to the person that I said came pregnant to work as a school worker. Okay. She said, yes, I came a few days ago to report to my employer, and because of my pregnancy, which I'm very heavily pregnant, there is no way I can commence work now. However, my problem is, now that I came, the company couldn't accommodate me because they realized I was pregnant. According to her, said the application, the company stated that they will accommodate me the first month if I come over. But when I came with that pregnancy, they said no, they couldn't accommodate me. They couldn't accommodate me with that pregnancy. Now I'm desperate and I'm destitute. My husband is yet to come and join me. Sorry, I'm reading, so pardon me if I'm missing some of the things. My husband is yet to come and join me. But from the look of things, I'm destitute and I want to report myself to the social services if there is any way they can support me, as I don't have anybody here to support me. Hey, lawyers man,
Yeah, I think that's the best thing to do.
that affect her and then affect the husband
No, no,
coming.
no. That's the best thing to do. She has to seek help from the council or the social service. She's not illegal, so it's not a big deal.
Oh,
The employer cannot take the risk of accommodating two people. The promise was for one person. It turns out that there are two people. So the employer is taking cautious step not to put this pregnant woman
yes.
in danger, because they have a duty of care to the pregnant woman and to the unborn child. And if they do something and it turns out that it wasn't the right thing, this same woman will complain. So they are being careful. So what the lady can do is what she has thought about. Yes, speak to the council or social service that you have found, and for the need of the child, they will come in and assist.
Okay. So the follow-up question here is that I said, would that affect my husband's application before he comes? And when he comes, what will be his what? Sorry, so would that affect his husband application? Of course, the husband is not here yet. So she's asking if she should go to the council or the social services. Would that affect the husband's application back home?
Well, she's not going to, even if she doesn't go, if it has to affect, it will affect anyway. For example, if she gets to the airport, he gets to the airport, and they want to check whether she's working, the
Uh-huh.
employer may say that she hasn't reported yet, or the employer may say that yes, she's working. It's what the employer says that matters, because
Matters.
they are not going to ask the social service or the council whether she's been getting help, because they wouldn't even know that she's getting help anyway. But what they know is that the wife is working for this employer. And if
Right.
they want to verify that the wife is here and working, they will contact the employer or they will contact the wife herself.
Okay.
Yeah. So,
Right. In that case, let's just end there by mentioning the numbers, the people that have been able to answer our quiz. Derek says number one. Tiliduma says number two. Who else? Some Ura Ajua, hey, Irajua, sorry, forgive me. Irajua says number one. Keep coming, keep coming. We have Kevin Asamoah says number two. And we have Adamunukum say number one. We have Lasma, our time is up. What will be the decision? Yes, I've read that one. And what will be the answer and why? Lawyer Asma, before we.
right. So, the fact is this person didn't want to waste food and felt that instead of we wasting it per our wastage policy, waste not policy, can we do something else by maybe buying it or discounting it? So that's an innocent approach. He hasn't stolen anything, so there's no crime here or theft of a sort. Just that he has not followed the company's procedure to do something. What he did was right, but he didn't do it within the rules. Is this fair for the employee? Will it be fair for the employer to dismiss? The employer will dismiss because they will say he didn't follow the procedure, but it will not be fair in all circumstances in this context, and therefore reasonableness test will not be met by the employer if this employer were to go ahead to dismiss, and therefore decision to dismiss will be unfair, and therefore because it would not have been reasonable.
Okay. So those of you who wrote number one, well done, well done. And on that note, we are drawing the curtains to a close. But before we do so, remember Christmas bonanza is coming very soon. There will be we'll start our quiz for Christmas bonanza. So look out for questions, look out for our nuggets, look out for all the every Monday motivations, everything that BWF Solicitors we've been posting on the media. Look at them carefully. And I believe if you are able to look through most of them, when we bring or we are doing the quiz, you definitely get your answers right, and then you stand a chance of winning nice surprising prizes. You know what it is. You know when it comes to BWF Solicitor what they can do. So last ma'am, we've come to the conclusion of today's program. Is there anything else you would like to tell us before we finally draw the curtains?
So what I would say is that let's be careful and diligent prospective employees, those of us who are still looking or applying to come to the UK and work. The conversations we've had today can point to the fact that the Home Office checks whether the COS is correct or genuine, or not whether it was issued by them to you. If it turns out that it wasn't issued by them, then they will conclude that it's a fake document. Fake document will result in a ban. So let's be very careful. How do I know that the employer is the right employer? You have to open your eyes, open your ears, and make sure that you smell the right people in your attempt to get the sponsorship to come and work in the UK. So just make sure that you probe more. That's all. Make sure you probe more. Now, today we have said that if you are banned under paragraph 9.7.2, it's not just the COS document, but it could be any document at all. And it's also the case that if your information on the application form turns out to be false, they will say that you did so with a view to take immigration advantage. There's always a duty on the Home Office to put you on notice by way of giving you a minded to refuse notice. What it means is that they have to tell you that they have picked something up. They are alleging something, give you time to clarify before they make a decision. And if you're not able to, then they go ahead to decide. But before decision, that opportunity should have been given to you. And that is also something you can rely on to make the challenge. I should have been given a mandate to refuse notice. Now, if it's a bank statement in the same format, there's one case where they boarded on bank statement. They said they checked the bank statement for the student, and it turned out that the bank statement was not genuine. The person brought a letter from the bank. It was a rural bank. The person brought a letter from the bank, and I used the letter to challenge the ban. They removed the ban and kept the refusal discretionary. So they moved it from mandatory 9.7.2 to discretionary 9.7.1, which has no effect of a ban. So those are the things that you can do. There was another student 2 years ago that we managed to get him to have the ban lifted, and he was able to apply again to come to the UK to study, having had the refusal decision amended to remove the ban. So in removing it, you have to make sure that you have the rebuttal or the information you have to suggest that what they are saying is not true. So if it's COS, where is the evidence from the employer to suggest that you went through the process and you were issued with this? We need that. If it's a case of bank statement, where is the letter from the bank confirming that the bank account existed at the time, the transactions were genuine and accurate at the time, and everything else from their view? We use it to challenge. If it's a case of birth certificate, we need a letter from the birth and death registry confirming that the document exists in their database and that it's verifiable. If it's a case of death certificate, a letter from the birth and death registry verifying the authenticity of that. If it's a case of marriage document, a letter from the registry of marriages confirming that. If it's whatever document, the issuer should be able to write a letter to confirm that it is to the best of their knowledge and the information available, a verifiable document, and we use it to challenge the ban. That this ban should not have been a mandatory, this refusal should not have been a mandatory refusal. It should have been a discretionary refusal. And in any case, this is the verification, and therefore they have to amend the refusal. Our aim is to get it from refusal to a grant. But even if you don't get a grant, the severity of the punishment, which is a ban, should be something that you want to take steps to remedy, because that's going to stay with you for 10 years, and that is a serious matter. So please, if you've been experiencing that, if you've gone through that in the last 28 days, please take action. And what if it's more than 28 days? It should have been done within 28 days, unless, of course, you didn't receive it. It's always the time you received it. So if you received it later, then we can count from the date you received the email or your decision, not the date that is on the letter. The date you received it is the starting point, and use it to make a claim. So please, don't sleep on this. Make sure that you take action and get this resolved. We are here to help. Thank you for your time. We'll meet again next week.
And thank you, Lawyer Asma. Yes, thank you, viewers, all those who came on board. God bless you. We believe next week, same time, you'll be with us. My name is always has been Magnetain. I salute you. Have a beautiful. See you again.